We have.
Well, good evening, Gerald. Thank you so much for joining us. It's a great shame you can't be with us, but we're very grateful that as one of our previous Vice-Chancellors, you're able to take part in this event.
Well, thank you for giving me the opportunity. I felt very bad about letting you down and not being able to come to what I'm sure is going to be a fantastic evening. And I hope not condemned by the tremendous snowfalls that we encountered 5 years ago, which nearly led to the whole audience being locked in to the hall for the night and unable to get home. But no doubt that won't happen this year. Fingers crossed.
Well, I hope so. Since this is pre-recorded, you never know. So, Gerald, what I'd like to start with, Gerald, is you're really from Lancashire. That's where you started, is that right? And from a farming family. Yeah. So,
yes. Well, my father's family farmed in Kent, but like so many other sort of soldiers who had demobbed at the end of the Second World War, he was desperate to get back to, you know, the land. And but the problem was, as I said, there were too many ex-soldiers so desperate, and result of which, you know, coming by a farm in 1945, 46, 47 was almost impossible, and the prices were sky high. And so, as I mentioned to you in the past, my parents acquired what was probably the worst farm in Lancashire at an extortionate price, which is where I was brought up.
So what was it then that made you decide upon the law as opposed? I can understand why you wouldn't go into farming with that background, but what made you go into the law? Was it something happened at school or something later?
Well, I loved farming, and I think had I not been thoroughly discouraged, you know, by my father from doing so, who said you never make any money farming, I might have been tempted, but there were various relatives who were lawyers, cousins, and also my sister was a solicitor, and so I think it was a sort of default thing. If you get to university, well, what are you going to read? I did classics A levels, Latin, Greek, and ancient history, and it didn't seem much point going on any longer with those subjects. I enjoyed them, but so law was, as I say, the default, and so I read law with a view to becoming a solicitor. But then my girlfriend at university persuaded me to go to the bar.
Yes, and your schooling, where you did this classical education you have, that was in Blackburn, is that right?
Yeah, St Mary's College, Blackburn, a wonderful school, 800 boys. The school run by Marist fathers. There were about 5 of these schools in England at the time, and achieved really, you know, incredible academic successes for its pupils. I mean, the school was sending about a dozen people to Oxbridge every year when I was going through the system there. And so I was incredibly lucky, actually, to have gone to that school, because my parents certainly couldn't have afforded full fees at a public school, and so I just fell on my feet really in going to St Mary's College at the time I did.
And they're from St Mary's College, I think Oxford, to take your degree. And from there, you told us about your girlfriend who suggested the bar. And you started in London, I think, as a pupil, is that right? But you didn't stay in London, is that right?
No, I got a pupillage in a way that probably wasn't very unusual in those days, but people would throw their hands up in horror now. One of the tutors at Oxford was what we called a weekender. He came up on a Friday and taught over the weekend, but he was a barrister the rest of the time. And anyway, through him, I acquired a pupillage with very little effort in London in a commercial set. And I did a pupillage there for 10 months. having already arranged a pupillage in Manchester, where, which is more in my sort of background, home background. And so I didn't get offered a tenancy after 10 months. They said, you've got to wait 12 months here. We don't make decisions at the 10-month point. So I was being hassled by my Manchester set, not unreasonably, because I was late coming. And so I just opted to go back to Manchester. And I spent 7 or 8 years doing knockabout common law in those chambers.
Well, I'd like to ask you about that. What sort of cases were you doing in Manchester as a circuiteer?
It was very, very nitty-gritty stuff. It was a mixture of quite unpleasant contested matrimonial offences, because there was defended divorces had more or less ceased by then, except in very rare cases, but matrimonial fallouts were often debated in the magistrates' courts, who had power to award maintenance and custody and things of that kind. And so the grounds for getting maintenance were always the same as the defended divorces. You had to show a matrimonial offence. Someone was dealing with unreasonable behaviour, adultery, desertion allegations, but in the magistrates rather than in the divorce court. So there was a lot of that, a huge amount of that, which put me off marriage for several years. And then the rest of it was small crime, motoring offences in the magistrates' courts, due care and attention cases. If you were lucky, you might get a totting up case, where you might get paid perhaps 5 times more than you'd be paid for a trial doing a careless driving case, but you were usually then defending a company director who was going to lose his license because he had the requisite number of points on his license to be totted up. So we did that. We did what was then called, were they then called industrial tribunal unfair dismissal cases? They were coming in.
That was started as industrial tribunal with
yes.
Yes.
So we did a bit of that. We did personal injuries in the county court mainly, and we did sort of small jury trials in the Crown Court. So it was the whole, coroner's inquests, quite a lot of those. In fact, my first ever appearance in court was at a coroner's inquest. And so it was a wonderful training ground, because you were doing a different sort of case every day. You were cross-examining lots of people all the time in court, so you're on your feet very quickly. Making a fool of yourself, really, but in fairly obscure courts, sometimes, dotted around the sticks, and huge mileage covered. I think I used to travel about 40,000 miles a year in my various clapped out cars. So, but immense fun. And I think quite a good, basic training to be a barrister.
But then you made this incredible change. I used to say to pupils, and it may be of interest to the young barristers here, that you need to reinvent yourself at the bar a few times, and you certainly reinvented yourself, because you went from this circuiteer common law practice to this rather specialist, high-level commercial practice, European Union practice. So how did you achieve that?
Well, I don't think I achieved anything really, because I'm sure, Philip, it's probably not your experience too, is that nothing at the bar is really plannable. Things just happen to you. And it so happened I was a bit sort of in a doldrums. My practice was sort of, not great in Manchester, frankly, and entirely through my lack of ability, and but I met someone who'd been a member of Chambers in the past, but who was now working in Brussels. So he said, well, if you're a bit fed up, why don't you come take, 3 or 4 months off and do what was called a stage at the European Commission. Yeah. And he said, I reckon I can get you that unofficially. You won't be paid like most stagiaires, but you'll be able to get some experience in European law, and then you can come back to the bar in Manchester and sort of hoover up all the European law work and have a specialist practice. So I wasn't married. I didn't have any responsibilities, so I just took off to Brussels and spent 3 or 4 months doing that, working at the European Commission in the legal service. And there I met the late, great David Vaughan, who was a pioneer, really, of European law at the English bar. And through him, I eventually got an offer to join his chambers in London, which was Brickcourt Chambers, is Brickcourt Chambers now. And to join him as the only other person to do European law in those chambers, because David was really on his own. Our clerk, bless him, the legendary Ron Burley, did not, in the early stages at any rate, think a great deal of European law, to put it mildly, and did everything he could to discourage, I think, David from taking it up. But David persisted, and I joined David. So then we doubled the number of people doing European law. And then we acquired the brilliant David Anderson, still practicing in those chambers as Lord Anderson, KC. Now, we acquired Nicholas Green, now Sir Nicholas Green, Chairman of the Law Commission and Court of Appeal Judge, erstwhile head of those chambers. We acquired him as a number 4. So, we gradually grew in Brickcourt until it became, I don't know what it is now, probably a third of chambers do sort of European-related work, including competition law.
And did Burley's view of European law change over time with this influx of practitioners and work?
Well, interestingly, he had a very close relationship, a professional relationship with Robert Alexander, who was said to be the best, almost certainly was the best advocate at the English bar in his day, and hugely in demand in all kinds of cases, commercial and otherwise. So we had been, as David and I had been instructed in a case by ICI. It turned out to be quite a big case, the first state aid case, where the ICI wanted to challenge some legislation that they said was granting an unlawful state aid to their competitors, Shell and Esso. And we decided that because it was going to be 4 weeks in the divisional court to begin with, a judicial review, we ought to really bring in some big guns. So we brought in Bob Alexander to lead both of us. And I think really we got Bob's endorsement that this European stuff, is worth powder and shot and is important and interesting. And Burley then changed his attitude, I think, to some extent, at any rate. I don't think he was ever a great Europhile, but I think he did at least realize it was good for chambers and there was plenty of work available in that arena. So that really, I think, was the changing point in our practices. The ICI, yeah. I
was going to ask you, sorry, over the Zoom, it's not so easy to time things, but I'd like to ask you about some of your cases, which will be of interest certainly to everybody here, but particularly the students here. But I'm going to go about it with a different format to the chat show format we're using. So I'm going to ask you to put your finger on the buzzer, and here's your starter for 10. I'm just going to read from a decision of Lord Phillips, the Master of the Rolls, from I think it's 2002 or 2003. The something litigation forms a notable chapter in the jurisprudence of this country and the Court of Justice of the European Communities. It is a lengthy chapter, and as this appeal demonstrates, one that has not been quite completed. The claimants were Anglo-Spanish fishing companies. Does that ring a bell?
Just about, yes. I expect it probably rings a bell with quite a lot of the students in the audience too. It's he was talking about the Factortame case, which went on for a long time, about 15 years of litigation, I think, altogether.
So can you tell us the background to Factortame? How did it come about?
Well, it reached us via a fairly sort of small firm of shipping solicitors in the city, who represented some Spanish-owned fishing companies And what had happened, I think, really, why the Spanish became involved was because Milford Haven had been a thriving fishing port back in the day, with 120 trawlers regularly fishing out of Milford Haven. And by the 1980s, it had dwindled to there were 7 trawlers left. And the town, from a fishing point of view, the town was dying. It was there wasn't any work for aspiring fishermen and all the rest of it. So, and I think when the Spaniards, when Spain joined the European Community in 1985, some very astute fishermen saw that they could continue to fish in their traditional fishing grounds off the west coast of Ireland under EU quota rules, and they would be able to do that even better if they could acquire more quota. So there were a lot of UK fishing vessels going begging up for sale with licenses, with quota attached to them. Quotas, I think, came in 1985. And so they acquired British fishing vessels already licensed and began to fish against the British quota, the UK quota allocated by the European Commission. So the same thing happened as far as some Irish boats were concerned as well. And the then government under Mrs. Thatcher took exception to this. They were lobbied furiously by Cornish fishermen who, interestingly, didn't fish for these kind of fish anyway, but who felt it was an outrage that Spaniards should be coming in and doing this. And the fish in question were hake, megrim, and monkfish, all of which none of which were in particular demand in here, and certainly didn't fetch the prices in the UK that they fetched in Spain. So, and they also had a different fishing method. They fished with long lines rather than trawled, and so they're caught on hooks rather than bottom trawling.
Yeah.
Anyway, so the government was lobbied, and they tried various ways in the early 80s. They tried licensing conditions to try and get rid of these Spanish fishermen. That didn't work because we acted for them in 2 judicial reviews prior to the Factortame case. And so then the nuclear option was adopted by the government. They said, right, well, licensing conditions hasn't worked. Those issues were all sent off to European Court, and incomprehensible judgments came back, which both sides claimed to have won as a result of. No one really knows who won the Agegate and Jadro cases, even to this day. But the licensing conditions were effectively dead in the water, to use the wrong phrase. But so they adopted legislation, and the legislation was very simple. The 1988 Merchant Shipping Act simply said that if you wanted to own a British fishing vessel in order to fish against the UK quota, and you had to get on the register to become a British fishing vessel, and you had to be 75% beneficially owned by British residents, domiciled and resident in the UK. Well, most of the owners, the beneficial owners of these UK fishing companies, were actually domiciled and resident in Spain or Ireland, and not in the UK, even though they landed a lot of their fish in the UK. They built ice plants in Milford Haven. They recruited sailors from Wales and other parts of the UK. So I think the court accepted, or the other side accepted, that they were putting millions back into the UK economy all the time, but that wasn't good enough to keep them fishing as British fishing vessels. So the legislation, once it was brought into effect, basically stopped them fishing overnight, and therefore
there were these 2 issues then which arose, because you challenged the legislation, didn't you? And you challenged it and sought interim relief to enable the fishermen to continue fishing. Yes. And to suspend the Act of Parliament. And how was that received by firstly, the Divisional Court and subsequent courts?
Well, the Divisional Court, a great court of Lord Justice Oliver and I think Lord Justice Derek Hodgson, who interestingly had been a former member of my chambers in Manchester. Derek Hodgson had, but I think we asked them to reach a final decision, but if they, as they very early said they wanted to do, if they made a reference to the European Court asking various questions, we asked them to give interim relief. So we knew they were going to make a reference on the substantive question of was the law contrary to directly effective European community law.
Yeah.
But so in the meantime, we wanted the boats to carry on fishing and to be able to carry on fishing. So we asked for interim relief, and the Divisional Court granted it. It was accepted by both sides, the government as well, that if we won the case, in other words, if we showed that the legislation was contrary to the rules in question of European law, then the Act of Parliament would have to be disapplied, as the buzz phrase went. But where they dug their heels in was to say, but you can't disapply it pending a finding that it's unlawful. It's an Act of Parliament. And so that was their argument, which the Divisional Court made short shrift of, but which found favour with the Court of Appeal.
Yes.
So we won in the Divisional Court. We got the injunction against the Crown suspending the Act, but we then lost the injunction in the Court of Appeal, where it was what the Divisional Court had done was said by the Court of Appeal to be a constitutional enormity.
Yes.
So it was an unusual case, obviously.
And then the House of Lords, although they referred the matter to the European Court, they were not really in favour of interim relief either, were they?
Well, they said we need to ask the European Court, do we have to give it? So the implication was that we weren't really entitled to it absent European community law,
yeah,
providing some mandatory effect to give interim relief. And therefore, effectively, the Court of Appeal judgment, they said that sounds right, but we're going to ask the European Court to tell us whether we have to make interim relief available, even against an Act of Parliament and even against the Crown. Those are the 2 points that the government had raised. It said that you can't, an Act of Parliament is presumed valid, irrebuttably valid, unless it's declared to be contrary to community law, and therefore you can't get interim relief. They also said, in any event, you can't get interim relief against the Crown.
Yeah.
And so those are the two limbs that they stood on. So those questions were sent off by the House of Lords to the second reference now, because the Divisional Court had asked them the main question. Now the House of Lords asked the interim relief question. But in the meantime, the Court of Appeal judgment stood, and our clients went variously bankrupt, or had to find other places where they might fish. Had to sell their boats, some of them in fire sales, at a knockdown price because they were valueless to them, without licenses.
I was just looking at the timing of it. The Divisional Court, I think, was March 88.
Yeah.
And it wasn't until, I think, July 1990 that the case had been to the European Court of Justice. They said you can grant interim relief, and the House of Lords then granted interim relief. So there's quite a time in between when they were losing out.
Unfortunately, that's right. Even in those days, I think it might be a bit longer now, but in those days it was about 18 months to get an answer back. And I think we said, well, you should do it quicker than that. We asked the European Court if they could get the interim relief point back quicker, and I think they did.
Right.
Get it back within a year or thereabouts, rather than the normal 18 months. But by then, obviously, we got the interim relief then from the House of Lords, but it was too late for quite a lot of them.
Yeah.
We'd gone to the wall in the meantime.
And then, having got your interim relief, and then further the substantive reference decided by Europe that this was contrary to European law, you then had to fight to get any compensation. Is that right?
We did. there was this small window of normally you wouldn't get compensation if some actual piece of legislation was unlawful. It would just be quashed.
Yeah.
But under European community law, if the breach was, quote, sufficiently serious, and you could establish causation, and and that you could get damages against the state for a piece of legislation. So that was the as it were, what we hung on to for those who'd lost such a lot of livelihood. So we then made the claim in the original proceedings. I think we'd already put in a claim for damages in our original divisional court application, judicial review application, and that was eventually referred. Was it referred by the House of Lords? I think it was. I think it was found to be a sufficiently serious breach by the divisional court, and we either we leapfrogged to the House of Lords, or I can't remember any Court of Appeal hearing, but the House of Lords, I think, then made a reference to ask the European Court whether the breach was, quote, sufficiently serious, and what other criteria had to be satisfied before the state became liable for damages. Yeah, and that was another hearing in the European Court, which coincided with one or two other damages claims made by, I think, one from Germany was joined to it at the hearing, and I think the hearing was also, I think, BT had brought a case alleging that something was a sufficiently serious breach of European law. Failure, I think, to enact a directive into national law might have been. My memory is a bit faulty on that. So all these cases came on then for hearing in the Court of Justice at the same time, and which held that the breach, the factor-obtained breach, was sufficiently serious to sound in damages. So that opened the door then to a big quantification claim.
Yeah, and rather like a movie franchise, because I think that was Factor-Obtained 5 was when you got to the damages point, and then yes. Rather like the James Bond franchise, there was a change of actors, a change of cast.
Yes, yeah, yes. The original cast, as it were, of lawyers dropped out at that point. Our solicitors might have stayed in, I can't remember, but certainly there was a different counsel team who did the quantification, which was quite complicated because it involved insolvent companies and loss by shareholders. There were all sorts of issues relating to it, but there was ultimately an award. I can't remember whether it was a settlement or whether it was awarded by the court, but it was a very substantial sum that was awarded to those companies.
Certainly, they were still arguing about the costs in 2002, I think.
Factor-Obtained 8. Well, there you go. It's unbelievable, isn't it? And we did think that we chose the most boring name possible. There were 85 companies, and some of them had wonderful names. My favourite was Leicester Trawling Limited. I thought that was just a great name for a fishing company. I think Leicester's quite a long way from the sea, but I think Leicester Trawling should have been Leicester Trawling, but we thought Factor-Obtained had a sufficiently boring name to be the lead claimant.
And then, well, then there's another. So that was Factor-Obtained, and there's another area of the law where you had enormous impact upon us all, which a lot of the younger people here won't realise that on a Sunday there was no shopping apart from some exceptions to that. And you took a large part in changing the law on that, didn't you? You were very much involved. Yes,
David Vaughan's wife said that in Factor-Obtained we destroyed the UK Constitution, and that in the Sunday trading case we destroyed the UK Sunday. And I think she said it slightly tongue-in-cheek, but yes, it's hard to believe now that there was a piece of legislation as utterly inane as the 1950 Shops Act, which, as we never tired of telling the magistrates' courts, allowed you to buy alcohol, but not powdered milk for a baby on a Sunday. It allowed you to buy a pornographic magazine, but not a Bible on a Sunday. And there were lists of, of exemptions of things that could be sold, were totally arcane. No one knew why these things had been selected for exemption. But so shops like B&Q, for example, who had garden centres and DIY stores, they were known as mixed shops. So they could stay open on Sunday, but they could only sell some of the things, and in fact, very, very few of the things that they stocked. So you could go and wander around the store on a Sunday and buy the odd thing, but you couldn't buy mostly what you wanted to buy. It was a crazy, and if there were any good reasons for it, no one could now discover what they were for this protection. Sometimes said to be protection of shop workers, but no other workers were protected in the same way on a Sunday. So why shop workers?
I think there were different attempts to circumvent this, weren't there? So I think
yes,
motor accessories was an example. There's Hadley and Texas Home Care, and they were suggesting somehow that wallpaper was an accessory in some ways.
Yes, it got to that level, I think, eventually. The motor accessories defence was the only way that, these stores could stay open, was to try and run. If they were prosecuted, they ran the motor accessories defence. So everything became a motor accessory because you were allowed to sell motor accessories on a Sunday. And as you say, wallpaper was the most creative one, and the one that eventually brought the whole edifice toppling down.
It was wallpaper in the caravan. That was the
wallpaper for a motor caravan.
Justification.
So anyway, so that was the end, really. The coup de grace was given by the divisional court in trenchant judgment about the abuses of the motor accessories and other similar defences. So the DIY and garden centre retailers, there were a number of them, but notably B&Q, came to the European lawyers to see, was there any hope in European law?
Yeah.
And so we pondered it for a bit and said, well, it sounds as though, do you import some of your stuff from other member states? And they said, yes, we import a lot. I can't remember what the percentage was, but it was a substantial 40% possibly of the stuff we sell in our garden centres and stores. We do import, and from other member states. So we then examined this with the help of economists and worked out what it was, and on that basis we said, well, there's clearly an effect on imports, an adverse effect on imports, and under the then EU law, case law, and that really amounted to the law amounted to a measure of, in the jargon, equivalent effect to a quantitative restriction on imports. What was then Article 30? I think it's something else now, but it's still there in the treaty, and it's directly effective. And if you can show that a measure has that effect, then it's got to be justified in accordance with European case law. So that was the limb on which the cases, challenges and defences in the magistrates' court to prosecutions for staying open went forward. We said this law has to be disapplied, the Shops Act, because it has an effect on trade, significant effect on trade, and it's you can't justify it.
Yeah.
So, and then
the courts weren't very sympathetic, were they, to that?
Well, the courts in the UK, some of them made references to the European Court on the question.
Yeah.
Some of them just convicted the retailers outright, and some of them adjourned, because once the references had gone to the European Court, it was rather easier for the retailers to say, well, hang on, this is all now sub judice in the European Court, so you shouldn't convict us. So there were lots and lots of adjournments of prosecutions up and down the land in the period before the first European Court judgment came out. And the first European Court judgment was beyond our wildest dreams, frankly. It was in a case called Torvine, which is an area of Wales.
Yes.
And And the European Court said, yes, it's clearly, in fact, it's accepted that this has an effect on imports because there was no challenge to our factual findings on that by the local authorities. They accepted that. So they said, well, it's therefore prima facie unlawful under what was then Article 30, and it's got to be justified. It's got to have a motivation which is recognised by EU law, and it's got to be proportionate. And that's a matter for the national courts to decide. So boing, ping pong, back it came. And another 2 years of arguing up and down the land that it was impossible to justify this measure, which frankly, most of us really thought it was impossible to justify.
So were some courts saying it was proportionate and other courts saying it was not proportionate?
Indeed, they were. And I remember doing an appeal in Shrewsbury Crown Court. It took a week. They all typically took a week. And the judge there, very wisely in my view, found that it was disproportionate and couldn't be justified, and therefore the Section 50, the 1950 Act was unenforceable in that area. So and some courts reached the opposite conclusion, and so there wasn't a happy situation, frankly.
Yes.
So it had to go a bit higher.
Just looking at the authorities, you were involved in a case, I think, reported 1993 in front of Mr. Justice Ferris, where you were arguing sex discrimination in relation to this Sunday trading. And I think Dave Vaughan was arguing about the Article 30 point.
Yes.
And yet the Sunday Trading Act is, I think, 94. So the government were keeping up their objections really to bitter end.
Yes. Really. Yeah, I think various points of principle had probably emerged by then, and also it was by no means certain that whether the legislation would, what form it would take. I think, as you rightly say, by then I can't remember, had we lost by then because it went back from the House of Lords to the European Court to say, look, we've tried to deal with proportionality in the national courts, as you suggested in the Torvine, but it hasn't worked out because courts are deciding different things. Please answer the following questions about what you were saying in Torvine. And then when the answer came back from the European Court on that reference, they kicked us into touch, basically. They managed to find basically they had to change EU law a bit, I think, really, to do us down, but they did us down. And so the Article 30 point went nowhere after that. And I think in the meantime, anticipating that might happen, we had come to the conclusion that there was a strong argument that the law was also discriminated on grounds of sex, on gender grounds, because it affected part-time workers who were mainly women, who actually, there was plenty of evidence that Sunday was a very important day for part-time workers to work. Yeah. They usually had responsibilities the rest of the time, but the husbands or the wives could stay at home and look after the children on the Sunday, but not in the week. So Sunday was an available day to work. So anyway, there was again, economists, I think, were deployed, and there was quite a strong case that this discriminated. Mr. Justice Ferris did not give me an easy ride on that point. As if you read that judgment, you'll see he was rather rude.
He struck out the statement of claim on that.
Yes,
that particular point.
So we came unstuck on that one too. But by then, the war had been won. The government then was committed to changing the law, and our efforts then changed to writing opinions on what kind of new law would be acceptable. Yeah. And we did. I remember having a very pleasant few days in a very nice hotel in Wales, writing opinions that were to be given to MPs who were going to decide on what the new law would look like. And it's pretty much, I think, what it is now. Very big stores can stay open for 6 hours or something, and smaller stores are not precluded from, staying open as long as they want.
Yeah.
So it was a wonderful saga with many lighter moments, and wonderful. Our case was described as a travelling caravan. It went around the country with the same lawyers, the same expert and factual witnesses, going from magistrates' court to Crown Court, and with a week-long trial at each one, and so everyone became very friendly with each other on the two teams, and so, as I said, we had a lot of fun doing those cases with nice clients, interesting points of law, and a good view of the country's legal system.
I can imagine. Well, listen, Gerald, it's been lovely talking to you. I'm sorry we couldn't go on and on and on, but we probably have anyway.
Well, I suspect we'll.
And I know everybody here wishes you well, and we hope to see you up here, maybe in the northeast.
Yeah, you find it difficult to keep me away. So anyway, thank you, Philip, very much indeed. And I really hope the evening goes well. I'm sure it will.
Thanks a lot.
Bye-bye.
Bye.